Hi, my name is Amanda Perrotten and I'm a partner at Bell Howley Perrotten. We specialise in providing tax advice and I'd like to introduce our latest guide in the series. This is directed at landlords and is the 5 dangerous myths about incorporating your property portfolio. It sounds like an exceptional title, but it's really important that you pay attention to these in order that any portfolio you incorporate is done properly and in a tax efficient and lawful manner. So what will you discover by reading my report, and why is it so important that you do read it? Well, firstly, there are 5 myths that you need to consider before you actually take the decision to incorporate your property portfolio. There is then the one biggest mistake that many people make before they make their decision. And finally, you will learn that by taking proper tax advice from a regulated professional, you will realise that you will be able to save tax, you will be able to avoid penalties, and you will be able to sleep soundly at night. Myth number 1. We've seen much information out in the marketplace that says that you need to wait 3 years before you can incorporate your partnership into a company. I can't see any legal basis for this other than some confusion over the implications of Schedule 15, paragraph 17A. Within my report, I explain why that 3-year rule is there for that particular element of the transaction, but it has no bearing itself on how quickly or slowly you should incorporate your portfolio. Myth number 2. You don't need to tell your lender that you are going to transfer the portfolio into a company, and you don't need to refinance the portfolio before you do so. This pays no heed at all to the signed terms and conditions that you made when you took the lending out in the first place. Importantly, within those terms and conditions, your lender requires that if there is any change in the beneficial ownership of the property, they must be notified and their consent must be sought to change it. Therefore, it is essential that your lender knows that you are going to transfer your properties from your personal names into your company, or that you refinance with a lender who is happy for this to happen. If you fail to notify your lender, and if you transfer a property without their consent, you will be in breach of your mortgage conditions. Myth number 3. You don't need to transfer all of the properties into the company at the same time. The reason that this myth is so particularly dangerous is it draws in the suggestion that there could be mortgage fraud. One of the key reasons for leaving the properties outside is to allow the fixed rates to expire that you have in your personal name. This is seen as benefiting from a preferential rate which you're not entitled to if you are suggesting that the company now owns the asset. This is something that you need to avoid at all costs. If you leave the properties outside of the company, you will also be endangering the entitlement to apply for incorporation relief. If this happens, you could have a significant charge to capital gains tax. You need to avoid this. Myth number 4. You should set up an LLP or a limited liability partnership whilst waiting to incorporate your property portfolio. You need to be aware that a limited liability partnership is an incorporated body in itself. So you are creating an incorporated body to then incorporate your portfolio into a company. This is unnecessarily complicating the process in itself. You need a simple partnership. This will mean that the lending will remain undisturbed for the period of the partnership. The partners who already own those properties will be taxed in the usual way that partners are. The partnership will be registered with HMRC and a supplemental form will be attached to your self-assessment tax return each year for the period of the partnership. When you then incorporate that partnership, the shares that are issued from the company will be issued directly to those partners personally. If you have set up an LLP, then the shares would be issued from the company to the corporate body of the LLP. This, as said previously, is complicated and is explained in our guide as to why you want to avoid it. Myth number 5. You should set up a company immediately prior to incorporation. HMRC are always looking for contrived steps. This means that in any process that they are reviewing, when somebody has mitigated their tax position, they will look closely at that transaction to establish whether or not they consider that there are contrived steps that enable the tax to be mitigated. This means that if they feel there are artificial steps that are generally unnecessary for the commercial transaction, they will discount any tax mitigation that is available. It is therefore important that you do not put in artificial steps during an incorporation if you want to claim the very valuable incorporation tax relief, and our guide clearly sets out how this can be done. Finally, the one biggest mistake that you can make. So what could that be? Primarily, it's failing to take proper, regulated advice from a professional. If it seems too good to be true, then it generally is. You need to find an advisor who will dispassionately inform you about your eligibility for incorporation relief. And if this is not available to you, then it would be unwise to proceed down this path. Have you thought about the impact of the following? HMRC inquiring into you and the way that you run your business. This leads to worry, sleepless nights, and a lot of stress. Have you thought about your lender demanding repayment of your loans? Again, this would be an enormous stress on both you and your business. Have you thought about the time that you would have to take in order to deal with any of these inquiries and these worries? By engaging with us directly, we will review your stamp duty land tax position and your capital gains tax position. We will provide you with full written advice on whether or not you will qualify for incorporation relief and how we will go about helping you. We are fully regulated professionals, and you can rely on the quality of the advice that we provide and the fact that we are regulated by professional bodies. Finally, our guide sets out what our solution is, and that starts with a conversation with you. It's important for you to give us a call, explain your circumstances, and have an initial conversation so that we can review your portfolio, review your position, and help you in the best way that we possibly can. So what's next? If you follow the link included within this post, you'll be able to download your free guide. Once you've read this, you'll be better informed about the myths that I have set out in these videos. We are here to provide the advice that you need in order to take the next steps. Drop me an email at amanda@bhptax.law and find out how you can benefit from our advice today. I look forward to hearing from you.